days. You had absolutely zero right, zero legal right, zero moral right, ethical right, all the right. Mr. Schmidt was dead on the money when he said, I sentenced you to probation and 3 days. Within 3 days, you committed these crimes. We will go on the record in the matter 23 CF 214, State of Wisconsin versus Bradley Scheuer. Oh, sorry, that's the 20. I'm not calling the new case.
Oh, you're not calling.
No, I'm only calling the, wait, you're right, the new case.
Do you want me to sit back in the?
Actually, no, you're right. I am only going to call the new case. And then I will call the old case after Mr. Davis excuses himself. So start anew. We will start afresh. We will go on the record in the matter 24 CF 202, State of Wisconsin versus Bradley Scheuer. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Scheuer in person in custody with counsel Nicholas Davis. We're set here today in this matter for a plea and sentencing. The parties have reached an agreement. Mr. Scheuer is currently in custody facing revocation on another matter. Mr. Davis, what is the agreement that's been reached?
Your Honor, the agreement initially was reached with Attorney Renicky, and I believe that District Attorney Schmidt is going to go along with that same agreement. My client was going to plead to count 3, Your Honor, which is misdemeanor battery. And it was just for both sides free to argue on this case.
All righty, so both sides free to argue in 24 CF 202.
And I should say at that time, District Attorney Renicky, I know that he always would include dismiss and read in. So those other 2 are not dismissed outright, they're dismissed and read in.
That is correct. All right. So Mr. Schmidt, what is the basis for the public interest in reaching this agreement?
I think being free to argue on that misdemeanor is fair. I think the way the false imprisonment was described by the victim, it's a little iffy. The strangulations are always about the effect on the victim, so there's always come down to testimony. The battery is the thing that we can certainly do. So I think that doing that and arguing with the read-ins is appropriate. Thank you.
Victim's rights compliance. Victim wish to make a statement? No statements made. All right. So, Mr. Scheuer, I have in front of me a plea questionnaire waiver of rights form. Do you recognize this document?
Yes.
And that's the document that your attorney went over with you? Did your attorney go over it with
Yes.
you?
Yes.
Did he go over it thoroughly with you?
Yes.
Did he essentially go over it word for word?
Yes.
And do you understand everything on this document?
Yes.
And if you didn't understand something, did you have him explain it to you?
Yes.
And he did so.
Yes.
And is that your signature on the second page?
Yes.
So you are pleading guilty to 1 count of misdemeanor battery. Is that correct?
Correct.
You are 66 years old. You have 12 years of schooling. You can read, write, and you understand the English language. Is that all correct?
Correct.
Did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Did your attorney go over with you the maximum possible penalties you face?
Yes.
You are not receiving treatment for a mental illness or disorder, and you've not had any drugs, alcohol, or other medications in the last 24 hours. Is that correct?
Well, I'm on heart meds, but
That's all.
yes.
No medications that interfere with your ability to comprehend or understand?
No, I've been incarcerated for 6 months.
All right. And so, did your attorney go over with you your constitutional rights?
Yes.
And did he go over them thoroughly with you?
Yes.
Do you understand them completely?
Yes.
You understand that you'll no longer have a trial. You'll no longer have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You will no longer have the right to testify on your own behalf or remain silent and not have your silence used against you. You will also no longer have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you will no longer have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand the rights that you're giving up here today?
Yes.
Now, do you also understand that if you're not a citizen of the United States, your plea could result in your deportation. If you're not,
Yeah, I'm a citizen.
I know, I have to ask that to everybody. Do you understand that the state would have to prove on or around September 6th, 2024 in Burnett County, Wisconsin, you caused bodily harm to JEC by an act done with intent to cause bodily harm to that person without that person's consent, a Class A misdemeanor? Do you understand what the state would have to prove?
Yes,
Do you understand that upon conviction, you face a fine of up to $10,000 or imprisonment of up to 9 months or both?
yes,
Do you understand that there is what's called a free to argue here? And that means that the state is free to argue for any sentence it feels is appropriate based upon the facts. Your attorney is free to argue any sentence that he and you feel is appropriate based upon the facts, but I'm not bound to follow either of those arguments or recommendations. Do you understand that?
yes,
That I am free in my own discretion based upon the facts of the case, as well as the totality of the circumstances, your history, rehabilitative needs, etc., the community, to sentence you to what I believe would be an appropriate sentence. Do you understand that?
yes,
Do you still wish to proceed and enter a guilty plea?
yes,
Now, did you go over the criminal complaint with your attorney?
yes,
In particular, did you go over that probable cause section that basically says what happened and why you were charged with the crimes?
yes, I read it, but I don't agree with it.
Well, and that's what I'm going to say. You may not agree with all of the facts 100%, but as it relates to this battery charge and the battery charge only, for those facts, are they essentially accurate?
No,
Well, I'm not taking his plea. We're going to go to trial because he's contesting it. He doesn't believe he did anything. We're going to trial. Okay, Mr. Davis, let's set the matter for trial. Then I'll move ahead and I'll sentence
I
him on
agree.
the other
I
matter.
understand what you're
No,
saying, but I do.
Nope, because you're not admitting to what you did.
Fine, I admit to it then.
Mr. Scheuer, I am not accepting a plea of an individual who is not going to be accountable and responsible for their actions, especially when it involves a battery to a person, a battery to a victim who did not deserve to have you put your hands upon them. Do you understand that? Now,
Yes.
if you're willing to accept that responsibility and admit to what you did, I will proceed and accept a plea. But if you are not, then we will go to trial. And I want you to tell the truth and be honest with what you did and your actions that day, or we will go to trial. I do not have any preference one way or another. I will not accept a plea if you are not guilty. I will allow you to attempt to prove your innocence or have the state prove your guilt beyond a reasonable doubt as to all of these charges to a jury. That is the justice system. So, Mr. Scheuer, I will again ask you, what did you do that day?
I put my hands on her.
You did. Did you? You put your hands on her.
That's what I'm charged with.
Yes.
Yes,
Did you put your hands
Yes.
on her? Did you have a right to put your hands on her?
yes,
You had a right to? The law says you can put your rights upon a person?
no,
Did you have a right to put
No.
your hands on her? Now, Mr. Scheuer, so you put your hands upon JEC, is that correct?
yes,
Did she give you consent to do so?
no,
Did you have a right to do so?
no,
Did you cause her harm?
yeah,
What?
yes, I said.
Yes, you caused her harm. Therefore, Mr. Scheuer, are you guilty of battery?
Yes,
Now, with regards to the facts of the case as it relates to battery, did you review that with your attorney?
yes,
Now, Mr. Scheuer, tell me right now, those facts as it relates to a misdemeanor battery, are they not 100% accurate, but are they for the most part as it relates to battery accurate?
yes,
Are you telling the truth?
yes,
Raise your hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Mr. Scheuer, are you telling the truth here today that the facts alleged in the criminal complaint as it relates to the misdemeanor battery are for the most part accurate?
Yes,
Are you stating here today that you in fact did lay your hands upon JEC?
Yes,
Are you stating here today that you in fact did not have consent to do so?
yes,
Are you stating here today that you did in fact cause bodily harm?
yes,
So, Mr. Scheuer, one last time, as it relates to the facts alleged in that criminal complaint, as it relates to battery, are they for the most part accurate?
yes,
Mr. Davis, may the court use the probable cause section as well as the statements made under oath by your client to find a factual basis?
I think the court has made a solid record, so I would agree with the recitation the court had with the defendant. Thank you.
Thank you. Now, Mr. Scheuer, has anyone made any threats or any promises to you for you to plead guilty to this charge?
no,
You're doing so freely and intelligently. That means you, yourself, you're telling me that you fully understand what you're doing here today,
yes,
and you're doing so voluntarily.
yes,
Now, when I walked into court here today, you were making jokes, you were talking to your attorney, you were having a good time. So that's telling me that you like Mr. Davis.
Yeah.
He's a good attorney.
Yeah.
He's a great attorney, actually.
Yeah.
He's a good guy, right?
Yeah.
You get along with him.
for the most part, yes,
Yes. Now, Mr. Davis, did he provide you at least competent representation?
I believe I provided him competent representation whenever he needed a question or a meeting or some kind of phone conference that was provided to Bradley.
So, Mr. Scheuer, did your attorney provide you competent representation?
yes,
Did he go over the facts of the case with you?
yes,
Did he go over the facts of the case with you as it relates to the elements the state would have to prove?
yes,
Did he go over with you the evidence and the discovery in this case?
yes,
Did he go over whether or not you have any defenses or a lack of defenses in this case?
yes,
Are you satisfied with his services?
yes,
Now, Mr. Scheuer, do you have any questions for the court?
no,
Your Honor, may I say, just have one sidebar with my client?
You may.
Remember, you wanted this done because you
mhm,
wanted.
mhm,
Remember, I told you that if you wanted a jury trial, I'll give you that jury trial. Okay. Your Honor, I just want to make a record. My client, again, he's ready to proceed and everything that he's put on the record is honest.
And for the record, I know you were talking to your client, but quite honestly, this is a courtroom. I have ears. I can hear very well. You were talking to him about his right to go to trial. He has the right to go to trial if he wishes to do so. That is his constitutional right, and he wishes to waive that right, and he wishes to enter this plea here today. Is that accurate and true, Mr. Davis?
It is. I just wanted to make sure one last time that if he wants to have a trial, I will make sure that I will represent him in that trial. And I said, well, and you will give him that access to that trial. And he said that he wants to go forward with this plea. I just wanted to double, triple, quadruple check on this.
And Mr. Davis, that's because you are a really good attorney, great attorney. He does his job very well and he's very thorough. So thank you, Mr. Davis, for doing that. So is that all accurate and true, Mr. Scheuer?
yes,
All right, so you wish to waive your right to a jury trial here today and you wish to enter a plea. Is that correct?
yes,
And Mr. Davis, based upon your conversations with Mr. Scheuer, do you believe he is freely, voluntarily, and intelligently entering a plea here today?
I know he is, Your Honor. Yes.
And he understands what he's doing by waiving his constitutional rights?
Bradley is an intelligent man. He understands.
All right, then. Any questions before we proceed, Mr. Scheuer?
no,
As to count 3, battery, and a misdemeanor, how do you wish to plead? How do you wish to
Guilty.
plead?
huh?
How do you wish to plead?
I said guilty,
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis based upon your statements under oath to find a factual basis in this case to accept your plea. Therefore, I will enter judgment as it relates to the battery. I will dismiss and read in counts 1 and count 2. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
Thank you, Judge. I would ask the court to consider doing a jail sentence of 6 to 9 months The court's first supposed to look at probation. I think probation is clearly inappropriate here because this offense happened 3 days after Mr. Scheuer was placed on probation on a different offense, a felony offense. So it'd be pretty wild under the McCleary-Gallion factors if the court did probation on this case. So for determining what would be appropriate for a jail sentence, I think that when we look at Mr. Scheuer's history, it goes back 20 years and it's pretty consistent. There's lots of alcohol-related offenses, OWIs of different levels. He has a lot of domestic and DC and battery type offenses. He's got a past pistol or assault weapon charge from McLeod County, Minnesota. So seeing that history and seeing those three things come together again, even though he has 20 years of history of it's kind of concerning. It's not kind of concerning, it's highly concerning. The conduct described here also involved weapons. The victim originally called about a machete and something else. Law enforcement saw him with a drone with a crossbow firing towards it. He didn't hit the drone. He hit the drone. That would have been just tens of thousands of dollars of restitution. So Mr. Scheuer's lucky he didn't shoot that drone out of the sky. This was an incident where, again, he hurt someone. He has past convictions for hurting people. He's been on probation numerous times. He's been to prison numerous times. With Mr. Scheuer, I think he's a person where we need to be thinking about punishment. We need to be thinking about specific deterrence. And we need to be thinking about general deterrence. The public needs to know, like, if someone, 3 days into probation commits same-ish type of offense that they've always committed, that it's not just going to be, well, the answer to this is more probation. Because then people know that their conduct isn't punished, and that opens up people to behave like that. Mr. Scheuer in particular needs to be communicated to that this will be punished. There's a ratcheting punishment system. The McCleary-Gallion factors are such that as time goes by and you commit more offenses, the penalties graduate upwards until you stop doing those. That's what specific deterrence is. So we've also clearly established that he does have rehabilitative, needs. Alcohol has been a primary driver in his whole life, and no doubt in this offense. But it can't be in the community with probation. Again, this happened 3 days into probation. So for those reasons, I think the court should do a jail sentence. It should be in the longer range. It should be 6 to 9 months. Thank you.
All right, thank you. Mr. Davis, argument and sentencing recommendation, please.
Thank you, Your Honor. Well, Your Honor, this case was interesting in terms of if it had gone to trial. I think there were some good defenses in this case, especially with regard to the felony, the 2 felonies, and even the battery. I'm not quite certain that the victim was even looking for any kind of prosecution. And I was suspect that the victim was even going to show up if it had been set for trial. However, in preparing for these cases, I have to also listen to the advice of my clients as they should listen to mine. But again, I work for the client. And I explained to Bradley, if he wants a jury trial, we can most certainly have it. And he knows that. And you grilled him on that too. But at the end of the day, he did put his hands on her, grabbed her wrists, and she said it caused pain. And so he's admitting to that. Again, there are different levels of battery. He's a convicted on a misdemeanor battery. That's not a badge. And I know that he has a prior record. Now, I've seen much longer prior records. I've gone through it and I've seen records that are not as long as his, but he does have a prior record with the OWIs, Your Honor. Those are certainly on there. I did see a felony bail jumping. I think I saw disorderly conduct too. I think that may have been St. Croix County. But in any event, he does have a record, but I wouldn't say it's where you go on the court access system and you're scrolling through 4 pages. Bradley's been sitting for a very long time. I know that he was, I don't have the exact number of days, but he's also been sitting on a hold though from the revocation. And so I don't have the exact number of days for this case. Sorry, he does because he's been sitting in jail.
And it would depend upon whether or not the court would do it consecutive or concurrent to any other sentence regardless.
He has 164 days for this case. Not that's just with this, not with what he's not with regard to the revocation. And so obviously you're going to be sentencing him here on a sentencing after revocation. And I don't know what's going to happen in that. But in this particular case, Your Honor, I don't see that there was any drugs or alcohol involved in this. And depending what's going to happen in the other case, I was going to ask the court to consider, I was going to ask for somewhere between 30 days and 3 months. And I believe that would be time served if he was given good time. And again, I would ask the court very respectfully and politely that if his whatever sentence he has, it can run concurrent to the case that you have next, Your Honor. You are aware of Bradley, you know Bradley. And when I was talking to Bradley, I get along with my client and we've gone butted heads before, but that's what usually I do with my clients. But I can tell you he's sincere. He's not a liar. And he admits to when he does wrong. And you asked him and he said that he did it. He was not allowed to touched her. And did it cause her pain? It sure did. And did he have the intent to touch her that caused pain? And it did. He did that. Now he's guilty of it. So I know that if he's not in jail, I know that he's able to work and be successful and take care of himself. He's not been a drain on society in terms of that. He's not a lazy man. He's not a stupid man. So I think when he's not in relationships that he should not be in, and this had nothing to do with drugs or alcohol, he's just a good person, and he means well and he does well. And this was not a relationship either. There was not a relationship between these two. That was more of a working thing.
That's what's weird is because in the criminal complaint, the probable cause, which comes from the police report, it identifies her as a girlfriend. It identifies her as something over a period of time, but this could have been something what could have occurred over multiple other incident dates.
And I suspect that I'm just suspecting when Attorney Renicky was going through this and charging this out or whatever, maybe he had contact with the victim in this case, and maybe she also said I was not in a relationship with him at this time period.
Well, and I will go over to the district attorney now to ask from their perspective, because I'm going to say quite clearly in the criminal complaint, which comes from the police reports, which comes from their investigation, which comes from the statements from the witnesses and the victims, it states she is the girlfriend. It states that on September 6, 2024, I, Deputy Henry, was requested by dispatch to respond to 26589 Old 35 in Menon Township. Dispatch advised that probation agent Lineweber was at the residence looking into allegations that Bradley Scheuer assaulted his girlfriend, JEC, last night. And if you go down, it says in the middle of the paragraph that she was worried about further retaliation from Bradley, as he told her numerous times that he knows people and he can hurt her even if he's in prison. And where else did it say? He threatened to burn her alive in the camper. Where else does it say other things like that? But
The defense agrees that
Mr.
that's in the complaint, but again, I don't think that she's saying that she was in a relationship with him. The only thing that I had read from it is they were investigating allegations that she was assaulted his girlfriend.
Schmidt?
I'm the one who charged it. The reason it doesn't have the domestic abuse surcharge is boyfriend, girlfriend is not something that creates the domestic abuse surcharge in Wisconsin. It's whether they're married or reside together or have children together. Being boyfriend and girlfriend does not make it a domestic abuse offense in Wisconsin. That is why I did not.
Well, and quite honestly, whether or not he's guilty of the charge and how it is charged doesn't really matter if it's boyfriend or girlfriend. Well, granted, if it is a girlfriend, you probably should care for that person and not want to harm them, but you shouldn't want to harm anyone. So, Mr. Davis, I don't know. I don't know if it's a girlfriend. I don't know if it's not a girlfriend. I don't have the victim here. I don't believe in court here today. I just know what was reported to law enforcement. And I don't believe that law enforcement would make something up and put that in a police report. And that's where we get the criminal complaints and the information from
Well, just
law
in
enforcement.
my argument, Judge, my client was not in a relationship with her when this occurred. And it's my belief that I think that she did live in Minnesota too at the time. They were not residing together. At least that's That's what I believe. And so I don't believe it was a domestic relationship as defined by the statute, but in any event, I'll concur. I don't care if a person's in a domestic relationship or not. If you touch someone without their consent and it causes them pain, it's a crime, and it doesn't make it any, well, I guess I agree with you a little bit on that too. I guess if you're in a relationship with somebody, there's a tie where you wouldn't want to hurt that person, but still, it's not good, and it's why there's a law, and that's why now he's convicted of a misdemeanor because of it.
And I'll also point you to page 3 of the criminal complaint where JEC also stated there have been times while they were staying at her residence in Minnesota where Scheuer has struck her, but she has never reported it. JEC stated when Scheuer had kicked the front of her knee last night, he told her that it only takes 10 pounds of pressure to break it, and she will not be walking out of there. She would be crawling out.
And again, I think the criminal complaint in Wisconsin, they're mere allegations. I think in the discovery, or if you get body cam footage, where you get also stuff from the victims writing in themselves, a lot of the times, I would say most times it's different from what's in a criminal complaint.
I'm just pointing to the fact that JEC was saying that there was some type of relationship, whether or not you identify it as girlfriend, boyfriend, there was a relationship beyond simply a work job.
And that may be, Judge, but I don't know if that was 5, 10, 15 years. Again, I don't know what she was referring to because it doesn't give a time, but I'm just saying, I don't believe that this was a domestic relationship as defined by the statute, but in the state has not charged him as such. But in any event, going forward, Judge, he's got the 164 days that he's sat. I know that I think the jail does have an effect on most people. I've had clients where they don't really care. Bradley does care. I know that he's climbing the walls. I know that he'd rather be out working and just doing normal things that people do out in the community rather than sitting inside the jail cell. And so for that, I think this has affected him. Again, I've got clients where they really don't care. Jail doesn't scare them. A prison doesn't scare them. But in this case, Bradley, it does. And so I'd ask the court to consider that 1 month to the 3 month. I'd ask there to be time served on that. And again, probation, it's not that I don't think probation is, I mean, I don't think that probation is not a good thing in this case, but with regard to for drugs and alcohol, I think that certainly I think probation is important. People can have some kind of monitoring, and I think they can also get involved in a lot of treatment, whether it's inpatient or outpatient through the probation agents. But in this case, he's never going to be having contact with JC again. In that whatever relationship the court wants to think that is, there will never be a relationship between those two. And for that reasons, I'd ask the court to consider my argument. Thank you very much.
Thank you, Mr. Davis. Mr. Scheuer, I'm now going to give you an opportunity to make any statement that you wish to make. You don't have to make a statement. You don't have to say a thing, but it's your only opportunity to clear anything up, to let me know anything about yourself that you wish for me to know, fill in gaps, fill in holes, whatever you wish to do. But again, you do not have to make any statement if you do not wish to.
I don't know if you ever read this statement. I wrote a statement of all the work I've done for her when I was at her house. I did a lot of work for her. My job for her was
I'm going to stop you right there. First, I don't believe that was filed with the court, so I have not read it.
Okay.
Second, you just need to speak a little bit slower. My court reporter takes everything down, and it's very hard to take things down when we speak really fast,
You
okay?
can read it if you want. It's your.
Well, that looks like a lot of words.
Yeah, I don't know. I could give it to the courts, but
And here's the question though. What relevance does it have what work he did for this individual?
Judge, I just think he wanted to impress upon you that the relationship was that of a working relationship. I think we've already got to the point.
What relevance does that even have?
Well, I think it does because the court brought up on multiple occasions that.
I'm just bringing up what's been alleged in the criminal complaint and how it was portrayed by JEC to law enforcement and how it was placed in the in the police reports. And Mr. Scheuer was asked at the date of the incident as well, and he didn't state counter statements to that fact. And then it was charged that way.
Judge, I'm not going to get involved. It says allocution. I really don't know what the limits are on an allocution, so I'll just stay out of that.
He can tell me anything he wants to know, but I don't need to be read every time you've done work for JEC and what it was. If you've done a lot of work for JEC, you can let me know you've done a lot of work for JEC and give me an idea of what it is you did for her.
I did a lot of work for her. I put up garage doors, put up garage door openers, cut down trees because I was supposed to roof her house. The whole key was to roof her house. That was the whole key of that, because she was dating my best friend. That's how I met her. She was with my best friend. That's how I met her. And then I went over to roof her house and I told her I wouldn't roof it until I cut down all these trees. And I cut down some pretty big trees. And otherwise, that's about all I got to say. But a lot of things she did when I was there, she would get upset. Wrong word, whatever. She would get upset at you. And I've had her throw oil on me. I've had her throw water on me. I've had her get mad. She get mad if you said the wrong word or did the wrong thing. She abused me with a fence post. And I got pictures of that.
So did you ever sleep with her, have sexual relations?
Yes.
Yes, so that answers my question. That's all I needed to know with regards to girlfriend, no girlfriend relationship, no relationship. Doesn't matter if she was dating your best friend or not, you slept with her. So it means to her that you had some type of relationship.
Yeah,
closer
sex buddy.
than just, because I'm gonna tell you, I don't sleep with my roofing guy. I don't sleep with the guy that fixes my garage doors. So it means that it was a little bit different than just a hired hand. All right. But anything else you want to let me know?
No, I'm good.
Okay. So all I heard there was excuses, 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 blame the victim, victim blaming, more victim blaming, and excuses. That's all I heard from you, Mr. Scheuer. I didn't hear any remorse. I didn't hear anything about that you're sorry that this happened. You should have never laid your hands upon her. No matter what, I'm going to tell you, even if the sky was purple and grass was blue and she got mad at everything that you did and she threw a brick at your head and caused you a concussion 6 months ago, even if she did that, okay? You had absolutely zero right, zero legal right, zero moral right, ethical right, all the rights to lay your hands upon her on September 6, 2024. Doesn't matter what she did or didn't do prior to that date, you had no right to touch her in any way, shape, or form. You had no right to lay your hands upon her. And some of these statements that she stated that you told her to law enforcement, OMG, like they are out of this world crazy. A crazy man says those things. How much pressure it takes to break a kneecap, and that she will be walking, what else did you say? I read it on the record already. These statements, these are more than just threats of harm. They're threats of egregious harm, more than substantial harm, malice, total torture. And you have no remorse. And you're not even looking at me right now. You're looking some other way because you're pissed off because I am telling you like it is. And you're mad because you wanted it to go your way. You wanted it to go your way. And it doesn't matter. It truly doesn't matter in the scheme of life and in the scheme of the legal realm, whether or not she is your girlfriend, or if she is a friend, or if she is a person on the street, or if she is somebody that hired you, in the sense of the legal word, you had zero right to place your hands upon her and to batter her. No right, but you did. Now, so that makes this serious. The fact that you have the criminal history that you do, you have an extensive criminal history, you have a crime that you're going to be sentenced for, not today. I'm not sentencing you today on that. For one, because you don't have an attorney, and you probably can apply for the public defender now since you are in custody. You don't have a job. I don't think you have income coming in. So you probably will qualify. And you need an attorney because the recommendation is prison. So that could be scary. And the second reason is because I think you need some time to let everything sink in, because this is serious. The other crime in the 23 CF 213 is significantly more serious because someone died. And you sit there cocked back in your chair like it doesn't matter. And you have an attorney who is excellent, by the way, who's excellent. An excellent attorney can't get the most guilty person out of the charges. Because you don't just catch charges, you commit crimes to get those charges. You committed crimes to be charged with these criminal acts. I have to look at the community and protecting the community. And Mr. Schmidt was dead on the money when he said, 3 days, I sentenced you to probation in 3 days. Within 3 days, you committed these crimes. And you're reading something, and Mr. Davis, I don't like that you're writing stuff to him while I'm doing it, or whatever's happening, because he's not paying attention.
I'm paying attention. I can hear.
No, because quite honestly, people can't really multitask. You can't read and listen at the same time. It's proven. All right. So this is important because this is your life. So I don't know what is more important than incarcerated, or whether or not you can walk free, or whether or not in another case you're going to go to prison, or whether or not you can have jail, or what's going to happen here and there. Because this moment is important. It should be the most important moment of your life. "3 days. It took you 3 days on
It's not a
probation
statement.
because this is extremely important. And I believe it's important. Okay, Mr. Davis, I don't know what that is. Can you please turn it around, because it's important to the state, it's important to the victim. It's
Judge, I
important
didn't
to
write
the
that. That's
entire
not my writing.
justice
It's, no, I
system.
don't know what it, I was just looking because it was there.
Is there
so-
anything that I need to know? What it is. If it's a
No.
statement and he wants to read it, he can surely read it, and I will wait and I will hear, because you have the floor.
If there's any additional thing you want to say, you can say it now.
No, I'm not
Well,
saying nothing.
apparently whatever
Obviously,
on
she's
that
right,
yellow
I'm wrong.
paper is more important than hearing what's going to happen in his case. So in 23 CF 213, which was a very serious matter in which an individual actually did die and a firearm was involved, the court placed you on probation with a withheld sentence. Within 3 days, you were arrested on these allegations. Within 3 days. And then you were in custody within 3 days of being on probation. That doesn't bode well for your case. And the fact that you're not taking this seriously, you're not showing any remorse, that you're blaming the victim, it's not telling the court that you are taking this seriously and that you are accountable. So based upon all of that and with the totality of everything involved in this case. With regards to count 3, battery, the court is sentencing you to 9 months of incarceration consecutive to any other sentence that you will serve. $443 in fines and fees. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. If you fail to pay your fines and fees, not only will you have a civil judgment entered against you because you're always going to owe it, but I will issue a warrant and you most likely will sit up to 6 months in jail for not paying. I need your DNA. The jail will make sure that they take your DNA with this criminal charge. You may be able to have it expunged from the system through a written letter to the Department of Justice. That is to the Department of Justice, not to this court. This is not a felony. This is a misdemeanor. Mr. Schmidt, what am I missing?
We'll just ask Lieutenant Mangan to get us the credit. We'll submit it to the court, and if there's any disagreement, then the defense can file a motion. Does that sound?
Well, I believe
Agreeable.
that Mr. Scheuer believes it's 164 days. I will give 164, and I will give Mr. Davis 7 days to get any different number.
Works for me.
The 164 days credit. Mr. Davis, what am I missing?
Nothing, Your Honor. Nothing further, Your Honor. Thank you very much.
All right, thank you. Then we are adjourned on that matter. I'm going to call the other case. We are setting it for a different date and time. I believe that for all purposes, it's necessary.
Your Honor may be excused now.
You are excused.
Thank you.
Yes. We will go on the record in the matter 23 CF 213, State of Wisconsin versus Bradley Scheuer. The state appears through District Attorney Kevin Schmidt in person. Mr. Scheuer appears in person in custody without counsel. We're set here today in this matter for a sentencing hearing on revocation. Mr. Scheuer was convicted of possessing a firearm as a convicted felon, a G felony. He was placed on probation with a withheld sentence back on September 3rd, 2024. He was arrested on new charges in which he has just been sentenced just recently today. He was placed on probation and was on probation for 3 days before he was arrested on new charges. He was revoked on this case and these charges. The court has received a revocation order and warrant packet. It does recommend a prison sentence. Mr. Scheuer does not have counsel. Mr. Scheuer, this is a serious case and a serious matter. I know that you indicated that you wish to represent yourself off the record. However, this again is a serious case with a recommendation for prison. Therefore, I would strongly encourage that you contact the public defender's office and you apply to see if you qualify. You have been in custody for a significant amount of time. Therefore, you may qualify for a public defender. I'm going to reschedule this matter for a different date and time to give you an opportunity to see if you qualify. If you do not qualify, then you can apply for a court-appointed attorney, and one could be appointed to you with a deposit. You have done that previously, and your son has put down a deposit for you. Again, this is a very serious matter with a recommendation of prison. So I'm going to give some time. I believe we need at least an hour. The closest I can get it in is March 24th at 1:15 on a Schmidt week. Because I'm leaving it on a Schmidt week, correct? Or am I okay to place it on an ADA week?
Either works for me. I think either of us can do it,
Okay, so then let me look.
whatever's convenient to the court.
How about March 17th at 10:30? March 17th at 10:30, that's an ADA week. That gives you plenty of time to apply for a public defender. Again, if you do not qualify, you can apply for a court-appointed attorney and have a deposit, and one would be appointed to you. Thank you. We are adjourned. All right, how are you doing today? I'm good. I'm sure you're feeling a little anxious. A
Yeah, a
lot
little
of
bit.
feeling.
Little anxiety there, but
Got a cool shirt.
What?
Got a cool shirt.
thank you.
Miss Hanu, timing wise, we're all good for today to proceed as it is.
Yes, Your Honor.
Excuse me, put my hearing aid in.
Okay, you do that. And if you need me to speak up, let me know. If you need me to turn up the system, let me know.
It's just my hairs.
So who's here with you?
That's my mother and my aunt.
Very good to have their support.
Here we go.
Anybody was curious, records prior to 1999 are stored in the basement of the Hennepin County Courthouse.
What?
I went to Hennepin County to dig through records.
Did you find anything?
No.
Nothing? But you tried hard. That's good. That's the problem with having things old, but now with everything in technology, we'll have records forever. Unless they let us purge them and delete them from a system.
Well, Washburn County's been down for about a week.
They're still down.
Yeah, they're going to be down for at least another week.
Everything.
So the DA's office runs off the state system. So they're all running off hotspots right now. So there's no phones, there's no Wi-Fi.
Wowza. All right, we will go on the record in the matter 25 CF 159, 25 TR 956 and 957, State of Wisconsin versus Eric Gustafson. The state appears through District Attorney Kevin Schmidt in person. Mr. Gustafson appears in person with his counsel, Emma Hanu. We're set today in this matter for a plea and sentencing. The parties have reached an agreement. Ms. Hanu, can you please recite the agreement for the record?
Yes, Your Honor, the agreement would be for Mr. Gustafson to plead to count 1, operating while intoxicated, a 5th or 6th offense. The remaining counts would be dismissed and read in. There are additionally 2 traffic matters that would also be dismissed and read in. That would be 25 TR 956 and 957.
All right. And Mr. Gustafson, that is the agreement that you've reached with the state?
Yes, Your Honor.
You understand that pleading guilty to an OWI 5 or 6 means that it's an immediate report to jail and that it's a mandatory minimum prison sentence. And that would be, as of me taking your plea, you're going to go and be incarcerated.
I understand.
Okay. All right. So I do have in front of me the plea questionnaire waiver of rights form. Do you recognize the document?
Yes, Your Honor.
Is this the document your attorney went over with you?
Yes,
Did she go over it thoroughly with you? That is essentially word for word?
yes,
And do you understand everything completely?
yes.
If you did not understand something, did you ask her to explain it to you?
I understood everything.
All right. And so You signed the second page.
Yes, Your Honor.
You're pleading guilty to one count of operating while intoxicated, fifth or sixth offense. You are 70 years old. You have 12 plus years of schooling. You can read, write, you understand the English language. You are receiving treatment for mental illness or disorder, which would be ADD or ADHD,
Correct.
and you are taking medications for that. Is that correct?
Up until my last appointment, because they won't allow it in prison, so I told them not to make it, because it has to be monthly, I have to go in.
Okay, now today, since you have not been taking it as you have been regularly prescribed the medication, are you in a place today where you can say that you are able to comprehend and understand everything that's going on?
Yes, Your Honor, it only affects my ability to concentrate.
All right, now, are you in a place here today where you can concentrate
Yes,
fully?
Your Honor.
Okay. Other than that, no medications, no drugs?
I have my
Or
own
alcohol?
medications, but those are just blood pressure,
All the
cholesterol.
normal health
Yeah.
stuff? Okay. Now, because you're charged, well, first off, did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt as to this OWI 5 or 6?
Yeah,
And did she go over with you the mandatory minimums as well as the possible maximum penalties you face upon conviction?
the minimum, yeah, I don't even know what the maximum is.
Well,
10 years.
Oh, 10 years, okay.
all right, so your attorney just informed you the maximum possible penalty. So you understand the mandatory minimum as well as a maximum penalty.
Yes,
Okay. Now, because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed right there in that first page. Your attorney is showing you your constitutional rights right now. Did your attorney thoroughly go over those rights with you?
yes,
And do you understand them completely?
yes.
Do you need me to go over those rights with you in any more detail?
No, I'm fine, Your Honor.
Okay, so you understand your rights completely. And do you understand that by pleading guilty, you are waiving and giving up those rights?
Yes,
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
yes,
Do you understand that you're pleading guilty to a felony? As such, you will no longer be able to use or possess a firearm for life.
that's why I don't own any.
Excuse me?
I don't own any, so that's
Oh, well,
why.
that's good. And you will no longer be able to vote in any election until your civil rights are restored.
With this political climate, why bother?
Well, that's good too. Okay, but every vote does count. Okay, so you understand your rights and you understand what you're giving up here today and that it's a felony. You
Yes,
understand that with regards to this charge, the operating a motor vehicle while under the influence, fifth or sixth offense, the state would have to prove on or around November 15th, 2025, in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of an intoxicant. Do you understand what the state would have to prove?
yes,
Do you understand that upon conviction of this Class G felony, you may be fined not more than $25,000 or imprisoned not more than 10 years or both? That's the maximum possible penalty. Do you understand that?
yes, Your Honor.
Do you also understand that upon conviction due to this felony and the seriousness of this OWI, that the court shall impose what's called a bifurcated sentence, meaning some time that you would sit in prison and time that you would sit outside of prison on extended supervision, that the court shall impose a confinement portion of that sentence to be not less than 1.5 years of initial confinement in prison. Do you understand that?
Yes,
And do you understand that in certain circumstances, it's not very common, but in certain circumstances, the court could find that a lesser sentence would be reasonable if the court finds the best interest of the community would be served and the public would not be harmed for a lesser sentence than that mandatory minimum. Do you understand that?
yes, Your Honor.
But you understand that's not an everyday thing that occurs. You understand that?
Yep.
Okay. So you understand the minimums, you understand the maximums, and you understand what the state would have to prove your guilt beyond a reasonable doubt. Now, do you understand that there is an agreement here reached between the parties where the parties would recommend to the court just to sentence the mandatory minimum in this case. Do you understand that?
Yes,
Do you understand that I'm not bound to follow that? Which means I could look at this case, I could hear the arguments, and I could sentence you beyond that minimum sentence, and I could go all the way to the maximum penalty if I thought it was warranted. Do you understand that?
yes, Your Honor.
Do you still wish to proceed and enter a guilty plea?
Yes, Your Honor.
Now, did you go over that criminal complaint with your attorney? That's the initial charging document that says basically what happened that day and why you were charged with the crimes.
Yes, Your Honor.
And you're looking at that right now with your attorney, correct?
Yes, Your Honor.
Now, for the most part, are those facts accurate?
They are.
So you were pleading guilty to an OWI 5 or 6 because are you guilty?
Yes, I am, Your Honor.
And so you're admitting to operating while under the influence on November 15, 2025?
Yes,
Ms. Hanu, may the court use the probable cause section of the criminal complaint to find a factual basis?
So stipulated, Your Honor.
Has anyone made any threats or any promises to you, Mr. Gustafson, for you to plead guilty today?
no, Your Honor.
You're doing so freely and intelligently. That means you're telling the court you fully understand what you're doing.
Yes,
Are you doing so voluntarily?
yes,
Has your attorney represented you competently?
yes,
Has she answered all of your questions?
yes,
Has she looked at this matter thoroughly?
yes,
Has she looked at the discovery, which is the evidence here in this case?
yes,
And has she discussed it with you?
yes,
Has she looked whether or not you have any legal defenses in the case or a lack of defenses? Did she say, you know what, looking at this case, it looks like we can argue to the jury and or the court that you have this defense and we can probably argue that maybe
Where,
find you not guilty? Mr. Gustafson, you can have a few minutes to talk to your attorney.
oh, okay, yeah. Yes, we talked about it.
Okay, and as she stated previously, I don't believe it was on the record, but prior to the record, that she went to Hennepin County, she went to go look at other OWIs that you've been convicted of to see if they had records of this, to see if you could possibly have what's called a collateral attack, which could be something that assists you in this case. Did you talk to her about that as well?
Yes, Your Honor.
Okay, so are you satisfied with her services?
Yes,
Do you have any questions for the court or for your attorney before I proceed?
no,
Okay, Ms. Hanu, did you go over the facts that are alleged in the criminal complaint with Mr. Gustafson?
Yes, Your Honor.
And did you go over what the state would have to prove his guilt beyond a reasonable doubt?
I did, Your Honor.
And the mandatory minimums and the maximums?
Thoroughly, Your Honor.
And you discussed whether or not you could see any defenses or a lack of defenses in this case?
Yes, Your Honor.
Do you believe he is competent to enter his plea here today?
I am.
Any reason the court should not proceed and ask for his plea?
No, Your Honor.
All right. Mr. Gustafson, as to count 1, OWI 5 or 6, a G felony, how do you wish to plead?
guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. Count 2 will be dismissed and read in. Count 3 will be dismissed and merged into count 1. The ticket matters will also be dismissed and read in.
Vacatum.
A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
Thank you. I think that the statutory minimum here is appropriate in this case. The defendant's got 5 prior OWIs, meaning this is a 6. The significant things that counsel for that are 1, the defendant's old age, which is 70. 2, he's been accepting responsibility quickly, not just with the court, not dragging things out, but also when he was in contact with the police out at the scene, he didn't really deny or anything like that. 3, he has a significant additional penalty in this case, and that even though this is a 6, it's his first felony conviction ever. The way Minnesota counts convictions is much more lenient than Wisconsin, which is how he's dodged that. His convictions are spaced out such that he never had 3 within a 10-year period, so he never had a felony OWI in Minnesota. So he's going from his last OWI in Minnesota where the penalty was just, 90 days jail, probation with 275 days stayed imposed to accepting prison today, which is a big jump. And I think that that alone is sufficient and there's no need to ratchet higher than that. Thank you.
Thank you. Ms. Hanu.
Your Honor, the factors you must consider here, the gravity of the offense is the statute as well as common culture creates the gravity is high here. I'm sorry. Operating while intoxicated is a issue here in Wisconsin. But the other factors that the court must consider is Mr. Gustafson's character and his rehabilitative needs and the protection of the public. Mr. Gustafson, as the court saw when we came here for a bond modification, was adamant that he wanted to go to treatment. He wanted to go get help prior to what he knew at the time would be an immediate report to prison. Mr. Gustafson was released from the Burnett County Jail on January 22nd of 2026. I have in my hand here a letter from the Veteran Affairs Association that by February 1st of 2026, Mr. Gustafson took the time to go to St. Cloud, Minnesota and enter into the mental health residential rehabilitation treatment program with the Veterans Affairs Health Center in St. Cloud. He completed that program on March 19th of 2026. Mr. Gustafson is committed to his sobriety. He served this country. As I think we all know, veterans often will struggle with sobriety, addiction issues following their service. As Mr. Gustafson has related to me, this came from a downward slope where he knew we needed help and he didn't get it in time, and now we are here. Mr. Gustafson is taking responsibility, and he is here today for the court to impose a sentence. I think the mandatory minimum is more than appropriate and adequately protects the public, because even after a term of confinement where Mr. Gustafson could get out, do his extended supervision and be done, he intends to re-enter into the Veterans Affairs treatment programming to ensure long-term sobriety.
All right, thank you. Mr. Gustafson, is there anything you want to add or you want to let me know?
No, like I said, I knew I was going, I just procrastinated. That's my biggest crime. Just trying to find my paperwork from previous groups I was in.
All right. Mr. Gustafson, sentencing people is not easy sometimes, because especially, I'm going to say for me, because I like to look at the person and I like to know about the person. So I have a good idea of who I am sentencing instead of just seeing the black and white. On black and white, if I were to just look at the facts of the case as alleged in the criminal complaint and those things, on black and white, it's serious. It's an OWI 5 or 6, and somebody could have been killed, somebody could have been injured, that could have been you, it could have been someone else. And if judges sentence on the black and white, you could go to prison for up to 10 years. I like to know the person who I am sentencing, to know the history, to try and craft a sentence around that person and that person's needs, as well as then looking at the punishment factor and what I am directed to do by the legislature and by my higher courts. From the very beginning, you have wanted to be responsible and be accountable, and you understood that, and you knew that you could just stay in custody and wait until the matter worked itself out, such as now, and plead guilty and go to prison. You could pay the bail and get released and then live your life until it reached resolution such as today. But you decided to pay the bail, get out of custody, go to the veterans facility and get the help that you need. mentally, physically, all around. Even still knowing that there is a mandatory minimum prison sentence in this type of case, you still went ahead and got the help that you need as a person. That's commendable. OWIs are very serious. Not only the legislature tells us that they're serious with continued increase, significant fines and fees, and significant penalties for OWIs. But you and everyone else in this courtroom, and including myself, know how serious they are because we either know somebody, had somebody in our family or a friendship or an acquaintance, or read in a paper or watched on the news somebody who was either killed or severely injured in an accident caused by intoxication or people being under the influence. So we all know that it's serious. You do have a criminal history, and it's obvious with the OWIs. This would be your first felony OWI, and in Wisconsin, it's mandatory prison. The community, I have to look at the community and protecting the community, and here, the community is going to be protected, one, because you went and got the treatment and the help that you need. And second, because this is a mandatory prison sentence and you're going to be incarcerated and you're going to get that punishment end of this crime. And so the community is going to be protected that way. Hopefully, when you are incarcerated, you will avail yourself of all of the programs and all of the activities and all of the things that you can to continue to improve yourself and to be able to have more self-reflection as to why this happened, what led this to be the result, and how you can catch things sooner or seek help faster instead of getting into another position like this. You're a 70-year-old man who appears to be kind and sweet, and you have support of your family, which is great to see too. So sentencing you today is not an easy thing, knowing that I must, I have to sentence you to prison. I don't think there's anything here, though, that would state that I need to or should look beyond the mandatory minimum prison sentence, because your criminal OWIs they're sparse in time, and you're doing all that you need to do, which is, again, commendable. So the court is going to sentence you to 1.5 years of initial confinement with 3 years of extended supervision. You will not be entitled to do any early release programming for that initial 1.5 years of incarceration, because that is a mandatory minimum sentence. However, once you're placed on extended supervision, if you are revoked off of that, at that time, you would be able to engage in some types of early release programming, substance abuse programming for early release, if you are revoked off of extended supervision. I am going to order $4,962 in fines and fees, plus a $10 blood draw fee. With each and every OWI, the fines and fees get higher and higher and higher. And I'm trying to give you as much of a break as I can, knowing that you're taking the responsibilities, because this could be up in the $6,000 range. I understand you're a veteran. I understand you're on limited resources. We do have $2,000 bail that has been posted. That'll go towards your fines and fees. When you're released from custody, you can petition the court to look at the fines and fees and see if there's anything that you can give back to the community, working with the veterans and doing those kinds of things, where I could perhaps knock some of the fines and fees off for community service.
Well, I've already made the decision to help out at the VA and local animal shelters.
And I'm glad to hear that. And you're telling me you're doing that without even having an incentive, without even having a benefit from doing that. So that makes me even happier. So when you are released, and if you are looking, or you would like some money knocked off to the extent that I'm able to, I am very happy to take your service with those organizations and help deduct some of the remaining cash that need, fines and fees. I can't waive any surcharges, but I can look at other fines and fees to try and whittle it down.
I don't,
Or out of custody, you will be making payments in the amount of $150 a month. If you're unable to afford that, again, you can petition the court. We can go over your finances and we can see if that needs to be looked at. Sometimes the court looks at your financial situation and looks at everything and actually increases the monthly amount. So just be sure that you don't think that that is a possibility. That would be, well, when he's on extended supervision, yeah, that would be to the Department of, correct, no, it won't. Let's have him pay us when he's released, because the Department of Corrections, he's gonna probably be watched in Minnesota, supervised in Minnesota, because you live in Minnesota, correct?
yeah, so when I get out, my family there lives up in Viking Village. At first I'll be going there
Okay,
because they need some help
all right.
mentally.
I do have to state that the Department of Corrections, in their discretion, could take a percentage for these kinds of fines and fees, and I'll leave it to them, but I'm comfortable with my comfort is you don't need to start making payments until after you're released, but the Department of Corrections gets to do what the Department of Corrections wants to do. And so if they have the authority to do that and to collect, and if they are looking at collecting, then that's something that you unfortunately have to take up with the Department of Corrections when you are in custody. On extended supervision, absolute sobriety, no alcohol, no bars, taverns, liquor stores, or any establishments that have the primary purpose for the sale or the service of alcohol. You will have alcohol testing. How many days of jail credit?
69, Your Honor.
69 days of jail credit will be applied to your sentence. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. If you fail to pay your fines and fees, not only will the court enter a civil judgment against you because you're always going to owe it, but the court will issue a warrant. You could sit up to 6 months in jail. This is a felony, no use or possession of a firearm for life, no voting in any election until your civil rights are restored. You're going to need to contact Burnett County Probation when you're in custody, or they will contact you, because when you are released, you're going to want to do that interstate compact, and you're going to want to transfer supervision to whatever jurisdiction you're residing in after release. I believe that covers everything. I need to order your DNA. The jail will make sure that they take that. In a case like this, I do not believe you can request it be expunged from the system, but you can try. It's a written letter to the Department of Justice. Ms. Hanu can help you if you wish to look into that.
At my age, I'm not too concerned about that.
Well, I'm glad to hear that. No, we don't have to worry about any past crimes where DNA will solve the mystery. So that's good. Thomas Avenue, is that your home?
That is my nieces. I've been there, but like I say, I'll be going there. I've been here for the last month helping them, and then I'll be going there when they first get out. And I don't know where I'm going because I think she's going to be moving to Florida while I'm incarcerated.
Okay.
I'm
just
hoping
make-
to go back to the neighborhood I used to live for 18 years till I had to move. That's why I went overboard there.
Just make sure that you have the Department of Corrections and the court updated with any change in address where you want mail to be sent, but they'll update us with where you are incarcerated.
I do have a change of address into my niece over in Hastings, Minnesota, that my mail will be going to.
You have an address you want to give us right now?
Yes. Let me pull it up. I'm trying to be proactive. 1988 Nininger, and that's spelled Nininger Road, Hastings, Minnesota, 55033.
Okay, thank you. All right, Mr. Schmidt, what am I missing?
Nothing from me.
This is an immediate report, so once you're done here today, in court, you have to go to the jail, turn yourself in, and get booked in, and, good luck to you, Mr. Gustafson.
So I brought these.
Good luck. Anything you think I'm missing or need to state on the record?
No, Your Honor.
Okay, thank you.
I just go down to the sheriff's office.
Yes, Ms. Hanu, do you have another case? Can you just show them how to?
I have,
Thank you.
I've been there before.
Okay.
Have a good day, Your Honor.
All right, Don Joyce, the individual from Mr. Meyer, can you hear me? And can you put me on video and unmute, please? Meyert, Mr. Meyert? Are you there, Mr. Meyert? Palo Alto, Iowa Jail? There
Yep,
we
we're
go.
here. Okay.
Thank you.
Can you hear us or not?
I can definitely hear you. Thank you so
Okay.
much.
Let me grab him real quick here.
Can you hear me, Mr. Mayor?
Yes, Your Honor. Yes.
How do you say it? Mayert or Meyert?
Mayert.
Mayert, thank you. We will go on the record in the matter 26 CF 79, State of Wisconsin versus Christopher Mayert. The state appears through District Attorney Kevin Schmidt in person. We have Joel Feliski, Defense Counsel, in person. Mr. Mayert appears by video conferencing in custody at the Palo Alto, Iowa jail. We're set here today for an initial appearance. Mr. Feliski, were you able to go over the criminal complaint with Mr. Mayert?
Thank you, Your Honor. I did have an opportunity to discuss the complaint here with Ms. Mayert, excuse me. I would note that she does go by, from my recollection, she, her pronouns. I had an opportunity to review that complaint with her. I believe she does understand the charges here, the maximum penalties. We will waive formal reading to any misdemeanor counts, enter in pleas of not guilty, and would request a preliminary hearing outside of time limits at this time.
All right, not guilty plea will be entered for the misdemeanor. We'll set a preliminary hearing. May I call you Chris?
Yes.
Chris, how long are you going to be in Palo Alto?
I'm actually going to be going to prison here for at least a 5-year sentence. So it might be a 10-year. They're working that out.
Well, you'll wait and see on that. So we're gonna try and get this one figured out as quickly as possible, I'm thinking then.
Yeah, I don't know how this process works over there. I mean, my stuff is
Yep.
mostly, yeah.
Yep, I'm just trying to get an idea of if you're still going to be in that jail in the next couple of weeks.
Probably. I mean, yeah, they think so.
Excellent, okay. And is there a time, it looks like you have a deputy or some other law enforcement person with you that may be managing the jail, and who can use Zoom and when? Can you see if there's a time that works best for us to have a hearing with you? If it's like a 9 o'clock, a 10 o'clock or whatnot, or is there any time to avoid setting a hearing?
I'd say afternoon is best, but he's right here.
9 o'clock's not bad. Anything after 1 o'clock is better. We're a single jail department, so.
All right, and I can accommodate afternoons. If you tell me afternoons are best, I will stick
Yeah.
with afternoons.
Okay.
And so what is the time where you are right now?
It's a little after 1, like 1:10.
Okay, so we're
Yeah.
on the same time zone. Just wanted to make sure.
Yeah.
I could do 2:45 on August 26th.
Okay.
And I'm just going to ask this just because I'm required to. Chris, are you okay with appearing by video conferencing?
Yes.
Okay, all right. And so if this is going to be a preliminary hearing and not a waiver, because Chris is requesting to appear by video, it would just be a stipulation to identity. You can discuss that with Chris, correct?
Correct, Your Honor.
All right, thank you. Chris, your attorney will be in contact with you, but we do have you scheduled for 2:45 on August 26th.
Okay, thank you.
All right, thank you. I see an attorney that I am not familiar with, so I am just gonna swap you on out.
Of course, Your Honor.
Benjamin Jansen and Mr. Whitaker.
Case number 26, CMN 1.
We will go on the record in the matter 26 CM 104, State of Wisconsin versus Quinn Whitaker. The state appears through District Attorney Kevin Schmidt in person. Mr. Whitaker appears in person with counsel Benjamin Jansen. We're set today in this matter for an initial appearance. Is this a case that an offer could be presented at this time?
1 sec, our system's been slow since noon too.
I believe this involved just lighting fireworks.
The offer we intended to make on this would be a 6 months deferred judgment and conviction on the DC.
All right, so Mr. Whitaker, what he is saying, and your attorney can go over that with you, what it means, as you said, a 6-month deferred judgment, like judgment of conviction, that's what you're asking for?
Yes.
Okay. That is an agreement, a contract. If you plead guilty to the crime, it'd be held over your head for 6 months. You'd have to pay an administrative fee of $150, not have any other crimes or not have any conduct that rises to probable cause for a crime. Pretty much that. It wouldn't need any AODA, none of those types of things. Pretty simple. If you complete all of that within 6 months, it gets dismissed, it's gone. So you can talk to Mr. Jansen about that, about if you wish to accept that offer. If he does, Mr. Jansen, the court can take care of it as in a quicker fashion. And if Mr. Whitaker is okay with that, as long as the court has the signed document before the hearing, you may appear by video conferencing. Save time, save money. But if you wish to have him in person, great too. So I can set a status out, Mr. Jansen. How far out would you like to have the status? But first, I guess he understands the charge and that maximum penalty.
He does, Your Honor.
Waives formal reading.
Yes.
Not guilty plea will be entered on your behalf. So how far out would you like the status, Mr. Jansen?
It really depends on the state. We haven't received discovery yet. 2 weeks after for a proper discovery review, and then a discussion with my client should be just fine.
They're very quick on getting discovery, and it's by a link. I don't know how you do it. I think you're from Minnesota. Are
No,
you-
I work at Door Drill and Scout in
Oh, do
Richmond.
you? Oh, I didn't recognize, sorry. Yes, so that's right. Okay. So yeah, if you haven't worked with the district attorney here before, it's relatively quick and it's still through that little link.
If that's the firm, they probably already have an account to get it.
Okay, so then it should be relatively easy. So I could do August 27th if you want it early, or I can push it out further.
August 27th should be fine with me, Your Honor.
I can do August 27th at 9:45 if that works. And if by chance you look at all the discovery, you speak with Mr. Whitaker and he wishes to accept that offer, we could handle it that day and take care of it.
Sounds good.
All right, anything further?
No, Your
Nothing from
Honor.
me, Your Honor.
Thank you. We are adjourned. Mr. Hammond?
I can get you your notice. You want your notice of hearing?
Mr. Whitaker, Quinn Whitaker, that just has a notice of your next hearing date and time. We'll go on the record in the matter 26 CM 103, State of Wisconsin versus Matthew Hammond. The state appears through District Attorney Kevin Schmidt in person. We have Amber Sherwood, Defense Counsel in person with Mr. Hammond. We're set today for a status conference. I believe this is a correlating case. Is the offer the same?
Yes, Your Honor.
The same offer. Would you like me to explain it to you as I did with Mr. Whitaker, or were you here, or were you listening and you can speak with Ms. Sherwood?
Sorry, I was
Oh,
doing something. I did not hear it, Your Honor.
It's a deferred judgment of conviction for 6 months, no special conditions, just not engaging in any conduct that rises to probable cause. And then the matter would be dismissed off his record.
Okay. Can I have
So-
one moment to speak with him so he knows, or can we set?
We're gonna set it out. But you did go over the criminal complaint with him?
I have, Your Honor, gone over the maximum possible penalties. We waived the formal reading and plead not guilty.
That guilty plea will be entered on your behalf. You are entitled to a jury trial, would be entitled to a speedy trial, should you request one. I can schedule you for 10 o'clock on August 27th. I know that's a short turnaround, Miss Sherwood. However, I did set the other individual for 9:45. I'm not sure if they need to be around the same time, but if once you get discovery, you discuss it with Mr. Hammond. If he wishes to accept that offer, I can take care of it and get the matter done that day.
Perfect. That time works for me. Does that work for you? That works for the defense.
All right, thank you.
Thank you.
Mr. Campo,
Would you like your,
sir, Mr. Hammond, it'll give you your date and time.
That's yours.
We will go on the record in the matters 26 CF 99, 26 TR 432, State of Wisconsin versus Brandon Campo. There may even be another one. Yes, 26 TR 637. The state appears through District Attorney Kevin Schmidt in person. Mr. Campo appears in person with his counsel, Joel Feliski. We're set here today in this matter for initial appearances and intakes. Were you able to go over the criminal complaint with Mr. Campo?
Yes, Your Honor, I did receive and review the criminal complaint in this case with Mr. Campo. I believe he does understand the charges and the maximum penalties. We will waive formal reading to any misdemeanor counts, enter in a plea of not guilty, and would request a preliminary hearing outside of time limits.
All right, not guilty pleas will be entered on your behalf. On all matters, you are entitled to a jury trial, would be, well, we'll get there. We're doing a prelim first. I appreciate your dress here today, Mr. Campo. You always look professional. All right. Always, it made you seem like you're here all the time. The other time I saw you, you look professional as well. Okay, outside of time limits. I could do August 31st. August 31st at 3:30. You're already coming for a prelim. I can set it then, at which time, Mr. Schmidt, I will put this on over to Mr. Vila's calendar.
That time will work.
All right. You can come get your note. Well, let's do bond. The court will reinstate bond, not with the cash portion, but reinstate it as $1,000 signature bond, same conditions as previous, okay?
Okay.
So you're gonna have to come up here before you leave, sign bond, and you're free to go.
Okay.
All right, do you have a question?
No.
Okay. Is that your last case?
Your Honor, I'm here to make a special appearance for Matthew Olson Jr.
All righty. All right, Mr. Campo, you can come and get your documents and you're free, well, to sign, and then you're free to go. Matthew Olson Jr.
Can we mail you out a copy of this? Copy machine does not work. Sign where that little pink dot is. Thank you. There's your notice of hearing. There.
We will go on the record in the matter 26 CM 89, State of Wisconsin versus Matthew Olson Jr. The state appears through District Attorney Kevin Schmidt in person. Mr. Olson appears in person with counsel Joel Feliski, making a special appearance on his behalf here today. We're set for an initial appearance. Before we even go down that road, is there an offer that can be presented?
The offer in this case would be an ordinance for possession of THC, dismissing but reading in the paraphernalia.
All right, so Mr. Olson, what that means is, if you don't understand, is the state is offering you to amend the crime of possession of THC down to an ordinance violation, like a ticket, all right, and to dismiss that other crime. So that is an offer. If you would like to accept the offer, and I'll give you time to speak with Mr. Feliski, we can take care of that here today.
I'd like to speak to an attorney more about that.
He did speak to me prior to this, Your Honor. He applied, but was not eligible due to income. I did provide him with the court-appointed application.
Would you be able to answer questions as making a special appearance about the ordinance offer?
I did discuss the possibility of that offer with him, Your Honor, and my understanding from that conversation, he would still like to consult with counsel first.
Okay, so you need a court appointed attorney, or you're gonna ask for one?
Yes, Your Honor. I have the application in my pocket for that.
You must fill it out before you leave here today.
Okay.
Where do you work?
At Kaywood Trust Company or
Wood?
Inc.
Mhm.
in Fallen,
And how much do you make an hour?
2150.
And you work full-time?
Yep. Yes.
Okay, what I'm going to need is $300 down before an attorney can be appointed to you, and it will be $50 a month that you have to pay towards the cost for the attorney, okay?
Okay.
So how soon would you be able to put $300 down?
I can do that on Friday, Your Honor.
Friday, the 14th?
Yep.
Okay, by 4 o'clock, are you able to do that?
I get off work at 3:30, so
So-
4:30.
4:30, they close at 4:30, so you have to be here a little bit before.
Okay, yeah.
4:30. So they won't be able to take it, but before end of business this Friday, put $300 down. And so he understands the charges and the maximum penalties,
I believe so, Your Honor.
Yes, Your Honor.
and not guilty pleas will be entered. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. I can schedule you. Once you pay the $300, I can appoint Daniel Chapman and give you a date of September 10th at 9. Oh, wait, wrong case. Sorry, it's a VLAW case. September 28th at 10:30.
That'll work, Your Honor.
Okay, September 28th at 10:30. And once you have the $300 down, then my assistant will appoint Daniel Chapman to the case. And you'll get an order with his contact information, and then you can give him a call and talk to him about the case.
Okay. Thank you, Your Honor.
You're welcome. You can come up here and get the notice. Please make sure you fill up that application before you leave.
I will. Thank you.
Miss Frazee, Jennifer Frazee.
Yeah, of course.
We will go on the record in the matter 26 CF 105, State of Wisconsin versus Jennifer Frazee. The state appears through District Attorney Kevin Schmidt in person. Ms. Frazee appears in person without counsel. We're set here today in this matter for an initial appearance. Ms. Frazee, you're here without counsel. Were you going to apply for a public defender?
Yeah, I just been having some troubles and hadn't had time to.
Well, I don't know where Mr. Feliski went, because you could have spoken with that gentleman to see if you qualify for a public defender. Oh, I didn't see you back there. You can do it.
I have 3 cases in front of you.
3 cases. If you can find Mr. Feliski, thank you.
Of course.
All right, so you'll meet with the gentleman that will come in here. You'll go meet with him to see if you qualify for a public defender. If you do, they'll appoint one to you. If you don't qualify, then we'll go over the court-appointed process, okay? So I'm going to briefly adjourn your hearing. I'll call you back as soon as you're done speaking with Mr. Feliski, and then we'll go from there, okay?
Okay.
Do you have her complaint?
Here you go, man.
Yep, show that to Mr. Feliski, okay?
I'm not sure where it is.
Drake Herman, is he in custody? All right, Ms. Sherwood, who would you like? I just called Drake Herman, but I don't have him here.
I have no information for the court.
All right, so we'll just call his case first. We will go on the record in the matter 26 CM 93, State of Wisconsin versus Drake Herman. The state appears through District Attorney Kevin Schmidt in person. Mr. Herman fails to appear. His counsel, Amber Sherwood, appears in person. We're set for an initial appearance. Mr. Herman was provided a ticket for this case with a mandatory appearance date of August 12th at 1 o'clock. He was provided that ticket. Then he was later summoned by the district attorney's office to be here this date and this time. And we have that he was actually served this in person, to his person, and he fails to appear. What is the state requesting?
I stand mute.
Oh, you represented him, that's right. Okay, stand mute. So what the court is going to do is issue a warrant, $250 cash. Only judge may quash or posting of the cash. He will be provided a new date and time upon posting. We are adjourned.
Thank you.
Mr. Kincaid? We will go on the record in the matter 26 CF 81, State of Wisconsin versus Brandon Kincaid. The state appears through District Attorney Kevin Schmidt in person. Mr. Kincaid appears in person with counsel Amber Sherwood. We're set today in this matter for a return on warrant. Warrant has been quashed in an initial appearance. Ms. Sherwood, were you able to go over the criminal complaint with Mr. Kincaid?
I was, Your Honor. We also went over the maximum possible penalties. We waived the formal reading, plead not guilty on the misdemeanor charges. We asked for a preliminary hearing, but waived time limits.
Not guilty on the misdemeanors. The court will set prelim September 3rd, 1 o'clock.
That was for the defense.
Okay, so September 3rd at 1 o'clock. All right, you can come get your notice and you're free to leave, except let me verify, are you still on Valley Boulevard?
Rich Valley Boulevard?
Oh, Rich Valley Boulevard. And telephone ends in 2256?
Yep.
May we send you text message notifications?
Yes.
Okay. If I see you're coming from a distance, if this is going to be a waiver of a hearing, your attorney will explain all that to you. If it's a waiver, he can appear by video or by telephone, as long as he has service. So he doesn't have to make the huge trip.
Thank you.
All right, you can come up here and get your notice and you're free to leave.
Thank you.
We have Misty Kirk.
Just giving you the Zoom information.
We will go on the record in the matter 26 CF 58, State of Wisconsin versus Misty Kirk. The state appears through District Attorney Kevin Schmidt in person. Misty Kirk appears in person with counsel Amber Sherwood. We're set here today in this matter for an initial appearance. Ms. Sherwood, were you able to go over the criminal complaint with Ms. Kirk?
I was, Your Honor. We went over the maximum possible penalties. We waived the formal reading. We asked for prelim waiving time limits. We expect this may be a waiver. May she appear via Zoom? Should it be a waiver, Your Honor?
All right, let me just see. I'm seeing in my case file, she has prepaid the restitution
Yes.
and she has a $500 cash bail in the matter. Okay, so this is one that will need a prelim, Mr. Schmidt. I guess it's a Mr. Vila case. You do 115, September 3rd.
Thank you, Your Honor.
All right, you can come get your notice and you're free to leave. Yes, if it is a waiver, she may appear by video or well, she's in Siren, so she can be here in person. All right, thank you. You can come get your notice. Do you have any others?
Nope. That's all mine for you. Thank you.
Hornsby. Alberta Martin. That's all I have.
The other one, the name.
You're, oh, okay. There, you're the victim of that case? Okay, all right. So she'll have a preliminary hearing on September 3rd at 1:15. Okay?
Or are you here about Alberta's case?
No, I'm the one, use my name in her.
Disorderly conduct. Whereas the district attorney has stated that on or around July 10, 2026 in Burnett County, Wisconsin, while in a private place, you engaged in violent, abusive, or otherwise disorderly conduct, which under the circumstances tended to provoke a disturbance. That is a Class B misdemeanor. Upon conviction, you could be fined $1,000 up to $1,000 or imprisoned up to 90 days or both. The district attorney has made an offer to you to resolve this matter. It could be resolved and taken care of here today. It's your choice offer, basically, to be handled today. He has offered that he would amend it or ask the court to amend it to a ticket, an ordinance violation, a ticket with a fine. And that could resolve the matter here today and it would no longer be a crime. Or you can accept an offer. He's made a second part offer that if you don't want the ticket, that you can plead to the charge of disorderly conduct and enter into an agreement, whereas it'll hang over your head for 6 months. But if you don't get into any more trouble, then the matter will be dismissed completely. So do you understand those two offers?
Yes.
Do you wish to accept either one of those offers?
How much is the ticket?
The
Do I have to
ticket
pay
would
it
be
today?
the ticket would be $500. You have the cash already posted. You'd get money back.
Okay. Then I'd probably rather pay the ticket.
All right.
Because
So formal
so I would get my bail back.
yes.
Yes, thank you.
Formal motion to amend to an ordinance violation.
So made, and we are in victim rights compliance because we specifically talked with the defendant's mother about this outcome.
Thank you. It is granted. The court will assess $500. Well, first, do you wish to enter no contest plea or a guilty plea?
No, not guilty.
No contest plea will be entered on your behalf. The court will assess $500. You will get the remaining amount of bail that you posted. It'll be mailed back to you if you are the one who posted it. Are you still on East 1027 Road? And I did not give your your numbers on purpose. Is that your address?
No, and I don't have an active address. They can't just put it back into my account that they took it out of?
They can't do
I
that.
I don't have an address right now. I just moved back. I don't have an address right now.
Do you have a friend or someone that we can do in care of and send it?
No, is there? No, I don't know. Is there any way I can get back to you and give you an address to send it? I'll have to go
Yes.
get a mailbox.
That's totally fine. Totally fine. Why don't you do that? This matter's taken care of here today. You're done. And then why don't you give the clerk a call, the court clerk a call, and you can tell her this situation and you can tell her when you'd be able to give her an address to send the money back to, okay?
Thank you.
All right, thank you. We're adjourned, and yes, I'll put you into a breakout session, Mr. Chapman.
Thank you, Judge.
Mr. Daniels, your attorney, Mr. Chapman, is going to have a breakout session with you. You're gonna have to hit a button, okay?
Right.
Okay, Zoom needs to be.
It's you, Mr. Chapman. I have to remove you. There, much better.
Thought I closed it.
We will go on the record in the matter 26 CM 81, State of Wisconsin versus Colin Daniels. The state appears through District Attorney Kevin Schmidt in person. Daniel Chapman appears in person as counsel. We have Colin Daniels appearing by video conferencing in custody in Burnett County Jail. Has an offer been presented, Mr. Schmidt?
It has, Your Honor.
Okay, and is it something that is being considered?
It definitely would be, except it involves Mr. Daniels getting some stuff done prior to the plea, which he can't do from jail. So I'm going to talk to Mr. Schmidt about other options. Otherwise, he should have a sentencing after revocation coming up pretty quickly, and I can't imagine he's going to sit too much longer for a misdemeanor.
Yeah.
So he can do it after he gets out, in
I
theory.
can fit it in relatively quickly.
I am not his lawyer for that case.
Oh, you're not?
No, I'm not. I don't know if I had a conflict on that or his other attorney had a conflict on my case, but for some reason it was assigned to two different lawyers.
What case number is that? Is it that the fleeing matter?
Yeah.
Oh, I see just you on the case. 25 CF 55.
Attorney White.
What?
It's Attorney White. He was appointed for the revocation, so he will then come in for the sentencing after revocation.
Oh, okay. Why do I say Dan? It says Daniel Chapman.
It's probably because I never opted out of CCAP after closing on the original matter, and there's nothing for Attorney White to opt into because it's just an administrative case at this point. But I'm sure he will be opting in for the sentencing hearing or calling you to schedule it. Did you privately hire Mr. White, Mr. Daniels?
Yeah, my dad had hired him for me because I was in jail. I couldn't get a hold of anyone.
Thank you. That explains it, Judge.
I'll just be a minute. I can schedule you. Mr. White is coming. Excuse me. August 25th at 10 for a different matter, and he will be in person. I need to look at that date.
I have two status conferences in Sawyer County at 9:45. I could make arrangements to appear for those by Zoom.
You can Zoom in. Yours is probably just going to be a status, but at that 10 o'clock, I'll have Mary reach out. I can probably do a sentencing. double book work because Mr. White's supposed to be here for 2 hours that day. And I don't think I need 2 hours for that one hearing.
Okay, that would be fine then.
So let's do 10 o'clock. August 25th, yes.
And if we resolve them both together, I will do my best to be here in person at that time as well.
Okay, sounds good.
What time on the 25th?
10 o'clock. We do have the Stewart competency hearing. However, I don't believe we need 2 hours for it.
I'm going to be cross-examining witnesses and perhaps bring a third.
So we might.
Yeah, sorry.
Well, let's do it at 10 anyway. We could probably even, there are 2 misdemeanors, perhaps. What would, well, he wouldn't be able to get them resolved unless you talk about a different offer.
Which I will.
Okay,
Otherwise, he can do the things Mr. Schmidt is asking him to do after he's done serving his sentence on the revocation and gets out again.
I don't anticipate sentencing on that other case will take long. Like you said, he's been in custody already a long time. Okay, thank you. We are adjourned.
Thank you, Judge. Mr. Daniels, give me a call if you have any questions, okay?
Alrighty, thanks.
Thank you.
Is that all on June 15? Oh, yeah. Mr. Meister, not here yet. Could you also, for me, please? Well, no, I'll have Mary do it. Never mind. I was just gonna say schedule the 25 CF55 Colin Daniels at that same time, 10 o'clock on the 25th. Have Mary send him a confirmation email. Yes. When you just set the 15. There's a bunch of people outside. Oh, they're just talking to Chapman. I don't see Mr. Meister.
This courtroom hearing takes a serious turn when Bradley Shire appears before the judge for a misdemeanor battery case while already facing a separate probation revocation matter. The court explains that Shire has agreed to plead guilty to the battery charge, with the other charges being dismissed and read in. But before accepting the plea, the judge carefully goes through his constitutional rights and makes sure he understands exactly what he is giving up by choosing a guilty plea. Shire confirms that his attorney reviewed the paperwork, the evidence, the possible penalties, and his right to a jury trial. Everything seems ready to move forward, until one question suddenly changes the entire tone of the hearing. When the judge asks whether the facts in the criminal complaint are accurate, Shire initially says he does not agree with them. His attorney immediately explains that if his client is disputing the facts, the case would need to go to trial. The judge makes it clear that she will not accept a guilty plea from someone who refuses to take responsibility. She tells Shire that if he is not guilty, he has every right to have a jury hear the case and require the state to prove guilt beyond a reasonable doubt. But if he wants to plead guilty, he must be honest about what happened. After being questioned directly, Shire finally admits that he put his hands on the victim, that he did not have consent, and that his actions caused her harm. The judge repeatedly confirms each part of his admission before accepting the plea. What makes this moment even more important is what happens during sentencing. The prosecutor argues that probation is inappropriate because Shire committed the battery only 3 days after being placed on probation for another felony. The state also points to his lengthy criminal history, previous alcohol-related offenses, domestic and battery-related convictions, and repeated periods of probation and incarceration. The prosecutor asks the court for 6 to 9 months in jail, arguing that punishment is necessary not only for specific